Distinction between criminal and civil proceedings. Criminal proceedings are distinguished from civil proceedings in the following ways. They are public proceedings brought by the Crown Prosecution Service or other public authority on behalf of the state. Private prosecutions are possible. The decision to prosecute will be made if there is sufficient evidence to provide a realistic prospect of conviction, and if the prosecution is in the public interest. The prosecution will be conducted on behalf of the state in a neutral and balanced way. The prosecution have no right to ask for the proceedings to be stayed, the sentence to be suspended or, indeed, increased. The result is conviction and punishment from a range of sentencing options. The role of the defendant is reactive, i.e., he responds to the standard stages of criminal proceedings. The prosecution will disclose all evidence on which they intend to rely and any relevant unused material before trial. The nature of the defense may not be fully disclosed until trial. Civil proceedings take place on the pleadings, i.e., written pre-trial documents setting out all the factual and legal points of dispute with full disclosure of the evidence beforehand. The objective in civil proceedings is to arrive at an early settlement. The objective in criminal proceedings is to find out as much as possible about the prosecution case and to hold your defense cards close to your chest.